Good morning, everybody. We're just waiting on a couple more people, so we will get started at 9 o'clock. Yeah, hopefully we'll get a few more dropping in before then. Just unmute my microphone. Right, so we'll get started. And if anybody else joins in during the next couple of minutes, then they'll obviously just miss the introduction, but that's okay. I can't see or hear anyone because it is done in the form of a webinar. So if you do need to get my attention, then please do use the chat function. If somebody might just give me a quick hello or thumbs up on the chat just to let me know you are all here and you can hear me okay, you can see my screen if possible before we start. Thanks, Ollie. Cheers. Okay, so let's get started then, guys. So welcome to our employment law update. So we know that most of you are probably aware of the various different things that Labour have promised. So Labour promised a new deal for working people within the first 100 days of entering office. You've probably seen an awful lot of chatter about what those things are. You're probably starting to wonder, what do I need to do? Do I need to change things? Do I need to panic? Okay. The simple first answer to that is no. Don't panic, okay? We don't need to panic about things. Nothing has actually changed as yet, okay? So don't be tempted to start adjusting all your policies and procedures. The simple fact is that we don't yet know exactly what that legislation is going to look like. There's going to have to be various consultations that are going to need to take place to get all of those proposals fit for purpose. The good news is that for those of you who are Cube HR retained clients, not an awful lot's really going to change anyway by the sounds of it, because we already advise you on kind of the best practice on how to do things in most of the areas that are looking to be changed. There are some simple things you might be able to do to prepare yourself, though, for what might come, and we'll run through what these are. What I'm going to suggest is, if you have questions, just make a note of them, pop them in the chat. Obviously, as I can't see or hear anybody, stick your questions in the chat for me, and what we'll do is at the end, I'll come back to all the questions that are in the chat in the order that they're put in there. And then that way it just doesn't break up too much the conversation. Okay, so the biggest one that you will all have heard about, that's probably the one that's panicking you most, is the day one rights for all workers. Okay, so the proposed change is that they are going to end the qualifying period for basic rights such as unfair dismissal, sick pay, parental leave, which means basically someone will have day one rights for all of these things. So that's going to apply for things like statutory sick pay. So currently statutory sick pay has a 3-day waiting period, which is unpaid. Parental leave, currently you have to have a year's worth of service to be able to access parental leave. So both of those would be a day one right. And of course, unfair dismissal is the biggest one. So what does that actually mean in practice? What it means is you're not going to be able to dismiss someone who's under 2 years service without good reason. Okay, you will still be able to utilise your probation periods as long as they're fair and transparent, and you will still be able to dismiss people as long as it's for a fair reason and that you follow the correct disciplinary processes. So there are a lot of thoughts that this day one right isn't going to be able to be implemented within the first 100 days. It is quite a big ask. However, I believe Labour have already been consulting with SMEs before they even came into power to try and get the consultation moving on this. So it's not unlikely that it might happen. When the right to claim unfair dismissal changed in 2012, when it went to the 2 years that it is now, it took 5 weeks to get through Parliament. So it is likely that it might happen. However, our belief is that during the consultations, the consensus seemed to be from businesses that they would like the right to claim unfair dismissal reduced, but not entirely eradicated. So there's a possibility that that might revert to perhaps a 6-month time frame or a 12-month time frame rather than being a day one right. So it is a little bit open at the moment to variation. Also, this rule is only going to apply to people who start at your company after the legislation comes into place. So, for example, let's say the legislation comes into place in September. Anyone who starts with you now will not be protected by this regulation. Okay, they will still be within that 2-year window. They won't have the right to claim as far as we're aware. What does it mean in practice? Well, a couple of things really. So, in terms of probation periods, you are going to have to manage them effectively. So, as an example, when you take somebody on in your business, they're subject to perhaps a 3-month probation period. After day one, you never mention that probation period again. You get to the end of the 3 months, decide they're not suitable, and you want to go ahead and dismiss them. That's not going to be applicable in this circumstance. It wouldn't be deemed as fair because you haven't followed a transparent probation policy. What you will need to do is make sure you do some probation check-ins. So have a procedure that you follow. If it's a midpoint check-in, if it's a monthly check-in, where you actually go through what the person is doing, their strengths, their weaknesses, and anything they need to improve on. If at the end of your probation period, be that 3 months, 6 months, whatever that is, if you can sit there and show them and demonstrate that you've actually had conversations with them already about their performance, then you should be safe to dismiss them. But if you haven't done that, you're not going to be. Another example of how this might impact you as an organisation, we get quite a lot of calls from people saying, got someone who's not really performing very well, been with us about 18 months, kind of had a couple of informal conversations with them about it, but we've never really done anything. We just don't think they're the right fit. Can we dismiss them? The answer to that is now going to be no. Okay, so previously, yes, employment review, bring them in, dismiss them. After this legislation comes into effect, that is something you're not going to be able to do. You are going to have demonstrated that you have followed procedures, performance management procedures, disciplinary procedures, and make sure that you follow everything to the letter. So, how can you prepare? I would suggest that you start to make sure that your probation period is robust and transparent. If you don't utilise your probation periods at the moment and you aren't giving feedback, then you need to have a look at a way to do that, because you will need to rely on those probation periods for new recruits. You won't be able to just coast to the end of the 3 months and 6 months. If you've got short probation periods like 3 months, it might be a time to start considering now, do we want to increase those to 6 months as a standard? It might allow you a little bit more leeway to assess someone's suitability, but do remember your probation period needs to be fair and reasonable anyway, so it might not always be applicable in the job roles. And get in the habit now of following your probation periods, get in the habit now of following your disciplinary processes. Okay, you will have to make sure you have a fair reason for dismissal. So that falls under one of 5 categories: conduct, capability, redundancy, some other substantial reason, or a statutory or legal reason. Okay, so you will have to have a fair reason for dismissal, and you will have to provide your employee with a reason that you are dismissing them. If you get in the habit now of always following those correct disciplinary processes, it shouldn't be too difficult when the legislation eventually does come into effect to make sure that you're already doing that. The next section is looking at family-friendly rights. So the biggest one on here, I think for me, that rang alarm bells was making flexible working the default from day 1. Okay, so a default right, except where it wasn't feasible. They might also limit the possible rejections for being able to reject flexible working requests. At the moment, there's 8 legal reasons you can reject a flexible working request. That may be limited down a little bit. We don't really know at this stage. But to be fair, actually, on balance, this isn't really that much different because everybody already has a statutory right to request flexible working. And we still have a right to follow a process, and we still have a right to refuse that flexible working request on reasonable grounds. That's not going to change. It's just that flexible working will become the default rather than a statutory right to request. Okay. They're looking at introducing statutory bereavement leave for the loss of a loved one. It will need defining what a loved one is. At this stage, we don't know whether that's just going to be family or whether it's going to extend to close friends, for example. And whether that bereavement leave will be a paid bereavement leave or not, I suspect it will be. They're also going to explore paid carers leave. So carers leave came into force in April, but it's currently an unpaid statutory right. So somebody's entitled to take 2 weeks off for carers leave each year. I suspect that'll probably come in line with other statutory payments. There'll be some kind of statutory carers leave payment that will be available for people. They're looking to review the whole parental leave system to try to make it more fair and effective for all. And part of that would be increasing those day one rights for parental leave, etc. And they're also putting protections in place for returning mothers. So for returning mothers, employers will not be able to dismiss returning mothers from maternity leave for a period of up to 6 months after return. They will be protected from dismissal. However, there has to be some exceptions to that. So the exceptions we're anticipating will be redundancy, probably gross misconduct. I suspect it's going to be more along the lines of not dismissing them for things like performance issues, absence issues, that kind of thing. How can you start preparing yourself for any of these changes? Well, we don't really know what all these changes are going to look like yet, so it's a little bit difficult to prepare in full. What I would say is you are going to have to be open-minded to flexible working requests. So if you are at the moment in a mindset where you don't believe flexible working is something that is applicable to your organisation, I suggest you start to have a look at the moment at what roles you have available, what your objections are, and whether you can actually open your mind a little bit more to that and make sure that you're already following clear processes for flexible working requests. There is already a responsibility on employers to try to encourage to advertise roles as flexible where feasible. So if you are recruiting for a job role, it may be that you do want to put hours on it and days of work, but actually maybe it is a flexible job role. Maybe it is something that is open to flexible working. So if you get into the habit of putting flexible working in your job adverts for those that are applicable, then again, it shouldn't be too much of a change for you to have to deal with that when that comes in. You may want to also already have a look at your bereavement leave policy. So our standard bereavement leave policy kind of includes up to 5 days paid bereavement leave for close loved ones, and it kind of filters down. I know some of you probably have policies that are discretionary. We provide bereavement leave, but speak to your manager about what that looks like, how much time you can have, what pay you can have. If you wanted to start to get some control over this now, there's no reason why you couldn't put a company bereavement leave policy into play that may then supersede any statutory bereavement policy that the government will put into place anyway. So that's something that maybe you want to have a look at to see, could we be more supportive through bereavement? There's a big focus on equality, so equal pay. So outsourcing will no longer be allowed to be used as a way of avoiding paying equal pay to people. That doesn't mean you can't outsource, but it's to try to stop people outsourcing to places like India, where the work can be done for £5 an hour, for example. There's going to be more emphasis on pay gap reporting. So any of you that have businesses that have more than 250 employees, you already have to publish gender pay gap reports. You are going to be required to also publish ethnicity and disability pay gap reports to show where those discriminatory elements might be falling in. And there's also been emphasis on menopause in the workplace as well. So again, for businesses that have more than 250 employees, you're going to need to put in place a menopause action plan. That's a plan that will set out how you'll support employees through menopause. There will also be some guidance for smaller employees on measures like things like uniform, temperatures, flexible working, not recording menopause related absences in your absence triggers. Okay. Ways you might want to be able to prepare for this. So if you do have more than 250 employees, are you collecting enough data from them to be able to provide reports on their gender, their ethnicity, and their disability in relation to their pay? Can you access that information quickly and easily to be able to do your reporting? If not, you may need to look at what systems you have in place to do that. I would also suggest taking a look at your menopause policy. Our menopause policy is a standard thing as part of our handbook these days. So most of you who are retained clients that have our handbook will have that in already. If you don't have that and you want one, then obviously just let me know at the end and I can sort that out. It may be worth looking at creating one now if you don't already have one. It is a big focus at the moment. It is a big topic. There are a lot more women of menopausal age in the workplace, and it is having quite a significant impact. So it's worth having that policy in place, even if you're not a 250 plus employer, as to how you'll support any employees who are going through menopause and suffering from symptoms of that. And then there's a large emphasis on fair pay as well. So the biggest one is going to be a complete overhaul of the national minimum wage system. So they are looking at a low pay commission being instructed to review and ensure that everyone has a wage they can actually live on. Okay, we don't know what that looks like in terms of figures at the moment. There is a national living wage at present. It's much higher in London than it is in other places. I suspect it will probably all come in line with that. Whether there'll be two bands, whether there'll be a London wage and an external to London wage, I don't know at this point. They're also going to be removing the age bands for national minimum wage. So at the moment, if you're under 18, you get a certain minimum wage. If you're 20 to 21, etc., you get different minimum wage. They're talking about removing those age bands altogether because they are actually discriminatory. There's no clarity as yet on whether this is going to be a complete removal of those bands. For example, apprentices at the moment currently get a lower rate of pay. Whether there'll still be an apprenticeship rate is not clear at this stage. There is also emphasis on making sure hospitality workers get their tips in full. So some of the tips legislation has already come out in terms of that. But they are looking to strengthen that legislation to make sure that all hospitality workers get their tips in full and that they're able to decide how they are allocated as well. So they have their own choice in how to do that. Banning unpaid internships unless they're part of an education or training course. And they're also looking to remove the lower earnings limit for statutory sick pay. So at the moment, you have to earn a certain amount per week to be eligible for statutory sick. I think it's about £123 a week. They're going to be removing that lower earnings limit for statutory sick pay so that everybody will have access to statutory sick pay. There's not a lot we can do to prepare for this because we don't really know what this is going to look like. If you are in an industry that has tips, consider if there's a way you can better manage them. There's lots of digital systems out there nowadays that allow you to easily manage tips that come through and would obviously meet any tips legislation that came out in terms of the government. Maybe taking a look at your pay structures already. You know, are you paying a fair wage to people? I'm sure most of you probably are. Maybe it's time to start getting some feedback from your team on what that pay would look like for them. And if you can get ahead of the living wage and you don't have to worry about the changes, then again, it's not going to have much of an impact on you. You may want to also have a look at your finances and availability in terms of funding if that living wage does increase significantly. I believe the living wage in London at the moment is, I'm not sure exactly what it is. I think it's somewhere in the region of about £13 an hour. So if you use that as a kind of a rough guide to say how much would it impact my business if I had to increase everybody's wage to this, it would give you a good idea of where you stand at the moment. You might want to introduce looking at company sick pay schemes as well. We already know statutory sick pay is not really fit for purpose. They are going to increase the rate of statutory sick pay, which we'll come on to in a minute in another slide. But actually, if you had a company sick pay scheme in place, it probably takes away any of the confusion around the lower earnings limits for statutory sick, who's eligible for statutory sick, whether it's a day one right or a day three right or how it works. So that may be something else that you might want to consider. And increasingly, we are hearing a lot more feedback from employees when we do our engagement surveys that they really want some kind of company sick because statutory sick is just not enough for them. Some other bits and pieces that they're looking to bring in, extending the time period for tribunal claims. So at the moment, an employee has 3 months from the time that they're dismissed or they raise their grievance, etc., to take the claim to tribunal. They're looking at extending this to 6 months. If that proposal does go through, along with the day one rights, they are going to have to do something to try and fund the tribunal system because it's seriously backed up at the moment already. There are cases on the docket that are a year ahead at the moment. I believe there's about 50,000 outstanding cases at the moment in the Northwest. So they are going to have to look at some more funding for the tribunal system to get judges in place and make sure the system's fit for purpose, because naturally, by making day one rights and extending the timeframes, we're going to see a lot more tribunal claims coming through. Looking to increase statutory sick pay, I would imagine they're probably going to bring it more in line with the livable amounts which of something like statutory maternity, statutory paternity. So the statutory family payments are actually quite a lot higher than statutory sick pay at the moment. I suspect they'll bring it in line with that. We're also looking to make statutory sick pay available for everybody. So all workers, including those who are self-employed. I'm not sure how that's going to work at this stage, whether they would pay themselves or how that would work through. There must be a claim place somewhere on the Gov website where they'd be able to go through to make that claim. And also those on low earnings, which we've already touched on, the lower earnings limit. They're looking to have a single status of worker. So at the moment, we have three statuses. We have employee, we have worker, and we have self-employed. So your worker is somebody who is a little bit like an employee, but has less rights in terms of unfair dismissals, in terms of access to holidays, sick pay, etc. They're looking to abolish kind of that category really and make the employee and worker category into one category. So they were uniting those two categories into one. This is in an attempt to try to avoid employers exploiting laws and taxes in terms of making people workers or self-employed when they're not really. They're looking to ban exploitative 0 hours contracts. So the key word there is exploitative. So we need clarity on what is exploitative exactly. Some people like 0 hours contracts. Some employees want the flexibility of a 0 hours contract, which suggests that then would not be exploitative. The proposed plan at the moment is to ensure that everyone has the right to a contract that reflects the hours they regularly work. So based on a 12-week referencing period. You're going to have to make sure you give reasonable notice of shift changes, and you're also going to be expected to pay compensation for cancelled or rearranged shift. What that compensation will be, we don't know. It'll be proportionate to the notice given for the changes or cancellations, but it'll end you having the capability to sort of cancel someone's shift an hour before they're due to come into work, etc., because you'll probably be likely to have to pay them for that shift if you do. Ending of fire and rehire. So we've already had a bit of legislation around this. So this is where we change somebody's terms of employment. Perhaps the terms are detrimental to the employee. They don't agree. So effectively, we terminate their employment and we rehire them on the detrimental contract. There's already been legislation put in place to prevent this in terms of consultations, etc. It will still allow for restructures. The aim is to stop people being forced onto unfavourable terms. So, you know, at the end of the day, if you're changing something within your organisation and it's not necessarily unfavourable for the employee, it's just different, there shouldn't still be an issue with that. But there is a proper process that you will need to follow that we can advise you on. There's no clarity at the moment on what's going to happen if an agreement can't be reached with an employee in those circumstances. But again, it will probably come down to having that fair reason for dismissal. Redundancy consultations are going to be determined by the whole business, not just one location. So previously, if you were making 20 employees at one location redundant, you would have to enter a formal prescribed consultation process of a set number of days. This would be now across the whole business. So if you have a business with multiple sites and you're making 20 redundancies across the whole of your organisation, then you would have to enter into that formal consultation timeframe. They're looking at introducing a single enforcement body to protect workers. So this is a body who will be able to inspect workplaces. They'll be able to bring prosecutions and civil proceedings on workers' behalf regarding things like health and safety, minimum wage, exploitation, so statutory rights, really. They're going to look at updating a lot of the trade union legislation. So there's a lot of protections coming in there for unions, strengthening unnecessary restrictions on union activity, strengthening the right of entry to workplaces for unions, simplifying union recognition, new rights to protect trade unions, and a duty for employers to inform all employees of a right to join a union. Now, that could just be a really simple one-liner that ends up in your contract or your company handbook. They're also going to look at strengthening the collective bargaining rights where unions are involved, including being able to make collective grievances through the ACAS system. There's a lot of piece of work going around about strengthening public procurement to support good work. I'm not going to focus too much on that because I don't think there's anyone really in the sort of the public sector in that way that it would be applicable for. Fair pay agreement for adult social care. So this is about negotiating fair pay and conditions for people in the adult social care sector. Things like staff benefits, terms, training. There has been mooted that they're going to be looking at addressing the pay during sleep-in issues. So where care workers stay overnight, required to sleep in for those duties. The right to switch off, so the right to disconnect outside of working hours and not be contacted by an employer outside of your working hours. There will probably be some exemptions for emergencies in there because I think there'll have to be. But essentially, somebody can't be penalised for not making contact with their employer out of working hours. So if you try to ring your employee at 7 o'clock at night and they don't answer, you can't then bring them in the next day and say, why didn't you answer my call, and penalise them for that. This kind of legislation is already in place in Ireland, Belgium, France, seems to work relatively well. There probably needs some clarity over what happens when people are off sick and whether we're allowed to contact them when they're on sick leave. And alongside the right to switch off is going to be the right to work autonomously. And this is the right to protect employees from remote surveillance. Um, Safer workplaces. So quite a bit of work going on around things like bringing back third-party harassment rules. So you will be having to protect your team from external people who come into your business. So for example, if you work in hospitality, for example, a customer comes in, sexually harasses one of your employees, you are required to take action on that in whatever way is applicable with that third party, essentially. More onus on employers stopping sexual harassment before it even gets started, strengthening protection for whistleblowers. There's going to be a new Race Equality Act, which will deal solely with sort of racial discrimination as well, reviewing health and safety guidance regarding things like extreme temperatures. So at the moment, there isn't really any guidance as to if a temperature drops to a certain amount in a workplace, or if a temperature goes over a certain amount in a workplace, what that temperature looks like as to when somebody has the right to say, actually, this is too hot, I'm going home. Preventative action and steps to ensure safety at work. And then there's going to be more rules around safeguarding against discrimination. So the Equality Act is going to be extended to people like interns, volunteers. Obviously, they're looking at the introduction of paid carers leave, family leave, and a lot of the other pay stuff we've already talked about will tie into that Equality Act. Okay. There are going to be more protections for self-employed people. Don't know what they are as yet. And also they're going to be focusing on bringing mental health on a par with physical health. So how can we prepare for some of these things that are coming? If you do use 0 hours contracts, it's probably time to start having a look at them. Are they fair? Has that employee on that 0 hours contract regularly worked hours for you for the last 3 to 6 months? Because if they have, maybe it's time to issue them with perhaps a minimum hours contract rather than a 0 hours contract. If they're genuinely 0 hours and some weeks they work and some weeks they don't, that's probably going to be okay as long as the employees are happy with that. Probably want to, if you do have shifts and you do end up cancelling shifts regularly, probably want to set a bit of a process for what that looks like. How much notice are you going to give somebody if you have to cancel the shift or you have to change the shift? Maybe, again, it's all about getting in the habit of good practices now so that you don't have to worry about changing things in the future. If you are looking at offering new terms to somebody because you want to change the contract for some reason, then it's a process that you need to follow. We would always advise you on that process anyway, but you need to inform them of the change and the reason. You will need to consult with them. You will need to hold formal meetings. You will need to attempt to find a compromise before you can actually then go down the route of actually we're dismissing you and offering you a new contract. Switching off from work. Okay, so we have a switch off from work policy in our standard handbook now, which talks about kind of people's rights in terms of not having to take their phones on holiday, not having to respond when they're out of the office. And I think it's really worth having one of those if you need to. What I suspect as well is that you'll need to lead by example. I'm guessing there's probably quite a lot of you that probably do send emails outside of working hours, that do make phone calls outside of working hours, that sit at your desk till 9 o'clock at night working, because obviously you're dedicated and that's what you want to do. But actually, you're going to need to lead by example for your team so that your team understand that they're not pressured to be contacted outside of work. And I'd say do that anyway, regardless of whether this switch off from work thing comes into effect. If you do have remote surveillance on your employees, so if your employees have your laptops or whatever devices at home, they're working from home, and you do have some kind of remote surveillance stuff on there, I think you just need to do a quick review to go, is it really necessary? Is it vital? Is it crucial? What is it offering you as a benefit to your business to have that there? Or is it literally just to spy on somebody because you don't necessarily trust them to work the hours that they're doing at home? Okay. Harassment, I think I've put on there, deal with any claims of harassment immediately. I'd like to hope all of you probably do anyway, to be fair. If you do get any grievances raised, anyone coming to you and saying, I think I'm being harassed, I think I'm being treated wrong, just deal with it, investigate it, go through the processes, ask for advice, seek out advice from us, seek out advice from whoever your other HR provider is, etc. Okay. Because of the fact there's going to be a lot more focus on mental health, have a look at your mental health policies and provisions that you've got in place. Again, we have a standard mental health and stress policy, which should cover a lot of the information, but it's a policy at the end of the day. That's just a tick box exercise to have a policy in place. What else are you doing to support your team's mental health? What other provisions might you be able to put in place to do that? Maybe worth doing a quick review of anyone who you've currently got who is classed at the moment as a worker or self-employed, to make sure that they have actually been correctly categorized, because maybe some of those workers actually are employees. Maybe some of those self-employed people might actually be employees. There are a number of different categories that are looked at to define whether somebody's an employee or not. It's not just about who pays the tax, which is the simplified version of that. The HMRC checker that you can get on the gov.uk website is a really good way to do that. You can put all the information in about the employee. It'll tell you whether it believes them to be an employee or a worker or self-employed on the basis of the information you put in. So it might be worth just doing a review of that. If you do have a recognised union, I'm not sure any of you do, but if you do have a recognised trade union, I'd suggest opening some conversations with the union reps now about what those reforms are going to look like in terms of the union stuff. So obviously, it might be worth getting ahead of that. They are going to have that information. They're going to be being told stuff directly through from Labour as to what that's going to look like. And I'd also, if you don't already, take a look at your current health and safety arrangements. So have you got robust policy in place? Have you got risk assessments? Have you got all the basics you need in place? We don't do health and safety ourselves, but we can recommend somebody good that can help you with that if you haven't got anybody in place that you go to. Okay. That's a lot of information. What do we need to do next? Can it all be done in 100 days? That kind of remains to be seen. I think some of it's going to take longer, to be perfectly honest. Things that probably will happen fairly quickly: trade union rights, the statutory sick pay reform, the national minimum wage reform, the day one rights for parental leave, the day one protection from unfair dismissal might also come in swiftly, as we've talked about. Things that might take a little bit longer, possibly the fire and rehire processes, bereavement leave, worker status, creation of that single body to deal with workplace disputes, and family leave reforms and pay gap reporting may take a little bit longer than 100 days to bring in, because they are going to have to consult with various bodies, and then obviously ACAS will roll out their guidance on what we need to do. As always, we keep our finger on the pulse. So as soon as we've got anything concrete on any of these proposed changes, we will keep you informed. If you're a Cube HR retained client, we'll update your policies by natural nature anyway, and any associated documents that go with those policies, and we'll keep you advised. If you aren't a Cube HR client at the moment, you're not a retained client, if you do want some help with any of this when the time comes, obviously please do reach out. We're always happy to assist you. That's the end of me waffling on. I'm going to just check the chat now and see about any questions that have been raised. And if you have got any questions, please feel free to get them on there now so that we can deal with them. So Sam's put, around the right to switch off, how do we cover technical support out of hours? So out of hours support, as Claire's put on there, will probably still be classed as working hours because it is an out of hours or an on-call service. So I can't imagine that's going to particularly change. It may just be that you're going to have to be clear in your contracts when people are on out of hours working, to be honest. Yes, Leon, we'll give you a copy of the presentation. I've recorded the webinar, so what I'm going to do is upload the recording to our client portal, so you'll have access to the recording, but I will also disseminate the presentation on there as well for you. Sam has asked, is it something we need to review in our employment contracts for technical developers? I presume that means for the out of hours support. Yeah, absolutely. I think we probably will need to look at that, but I don't think we change anything yet until we know what the legislation looks like, because we are really flying blind with this right to switch off area. In Ireland, I believe it is not a legislation, it's not a legal right, whereas in Belgium it is, and it depends which route they go down. So essentially in Belgium, if you contact someone out of hours, it's actually a criminal offence, because it's actually scheduled in law, whereas in Ireland it's part of kind of the employment best practice employment law stuff. So it's not a criminal offence, it's just a kind of a breach of contract. So we don't know at all what that's going to look like. We will absolutely review your employment contracts, and we will absolutely tell you what you need to do when we get more information. So yeah, we'll get the recording out. Any other questions, guys? Obviously, I can't hear anybody, so if you've got questions, you are going to have to put them on the chat, I'm afraid. Oh, okay, well, that brings us to the end of the session. So if you do want to stay on because you have got questions, that's fine. If you want to go because you're busy, I appreciate that, and I will let you know when the slides and everything are ready. Thank you so much for joining us. question coming in there from Aditi, just to confirm the rights would start from the day they begin. Yes, absolutely. So in effect, it's no different to discrimination rights. So discrimination at the moment, every employee from the beginning of the point where they start work with you, actually in some instances before that, because it's you can be discriminated through recruitment as well. They have a day one right to claim discrimination. It's just going to bring it in line with that. So whereas at the moment for unfair dismissal and constructive unfair dismissal, they have to have 2 years service, it will be a day one right of that service. So hopefully that's helped you.